He is extremely apologetic for that behavior, and I do not foresee that will reoccur. I would ask the court for the bond violations my client does admit to, for sentencing him to the time he has served in custody. He has been in custody for 12 days, Your Honor, and we are asking if the court would consider his release today.
Sir, you understand that the folks at community correction are never to be addressed that way?
I understand. It was just a severe lapse of judgment. And I'm really sorry. I'm not going to miss any more tests. I'm not going to it's not me. That's all.
Don't ever let me hear that you disrespected them.
Please state your name for the record, sir.
Hunter Hallis.
Thank you, Your Honor. Sir, this is the plea.
All right, what are we doing?
Your Honor, there is a resolution. Oh, I apologize. Your Honor, there is a resolution in this matter. My client is signing the plea form now.
Oh.
The offer in this case is for my client to plead guilty to added count 2 of misdemeanor aggravated assault with prosecutor's consent to HIDA, and in exchange count 1 would be dismissed. My client did just sign that plea form, and we did previously go over the advice of rights, and I signed on his behalf with his permission.
That is correct, Your Honor. Aggravated assault, of course, being contrary to Penal Code 750-81A, a 1-year misdemeanor and/or is a $1,000 fine of $52,000.
May I have him sworn?
Right hand. Solemnly swear that the testimony you give me the truth to hold nothing up you got.
I do.
State your name, please.
I, Hunter Hallis, swear that everything that I say, just my name, Hunter Hallis.
Okay. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of aggravated assault.
Yes, Your Honor.
Misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
That charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
Then you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody promised you anything other than what's been stated here today to get you?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
July 1st, 2026, at the location of 346 Village Green, number 205, Ann Arbor Township, Washtenaw County, State of Michigan. What did you do regarding a Paul Hallis that makes you think that you're guilty?
Your Honor, may I voir dire?
Okay.
Thank you. Mr. Hallis, on the date that the judge stated, were you and Mr. Hallis Sr., did you start to get into a verbal argument?
We did.
And did that argument escalate further to the point that you got a hunting knife?
Yes.
And during this verbal argument, did you threaten verbally while holding the hunting knife, Mr. Hallis Sr.?
Yes.
And was that within a physical realm where Mr. Hallis Sr. could have been in fear of an imminent assault?
I believe so. Yes.
Your Honor, I would ask the court to accept the higher charge.
Higher charge.
Yes, the people agree that statute is sufficient for the higher charge.
Oh, higher charge. Sir, I do have to advise you to commit misconduct between the time I accept your plea and the time of sentencing. That's misconduct as defined in the Michigan court rules. You would not be entitled to withdraw your plea. You understand that?
Your Honor.
All right. And the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
And have I complied with the court?
People are satisfied.
Yes, Your Honor.
Court will accept his court's plea his guilty plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation.
Excuse me.
Sentencing will be
At 10 a.m.
September 1st, 2026, 10 a.m.
Yes.
10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond when appropriate? Thank you, Your Honor. I know the court is in receipt of the motion for bond modification to convert Mr. House's bond back to a PR bond. Mr. Vignew from our office filed that. Your Honor, I did speak further to Ms. Feltes. It is my understanding, of course, she absolutely can correct me if I'm wrong. I do not believe the people are objecting to Mr. House's release today. Of course, understanding that he will be placed back on community corrections testing. We also, the defense has no objection if my client's testing would even be increased. As your Honor is aware, my client did miss some tests at community corrections and he did test positive for THC. My client did have a test that came back positive for cocaine. However, as your Honor is in receipt, my client did send that test out to the lab for confirmation and it came back that that was a pulse positive. So we do have confirmation that my client did not test positive for cocaine while on bond. However, as to the other bond violations of my client testing positive for THC and missing some tests while on bond, my client does admit those bond violations. And furthermore, Your Honor, Mr. Hallis and I did have a serious conversation about some of the language he used with community corrections when he was frustrated at the situation. This is not at all an excuse. He knows what he did was wrong and he shouldn't conduct himself that way. And he is extremely apologetic for that behavior. And I do not foresee that that will reoccur. I would ask the court for the bond violations my client does admit to, for sentencing him to the time he has served in custody. He has been in custody for 12 days, Your Honor, and we are asking if the court would consider his release today.
Sir, you understand that the folks at community correction are never to be addressed that way?
I understand. It was just a severe lapse of judgment, and I'm really sorry. I'm not going to miss any more tests. I'm not going to it's not me. That's all.
Don't ever let me hear in any way that you disrespected them. You hear me?
Yes, Your Honor.
I will sentence the defendant on the bond violation to 12 days, credit for 12 days served, and then I will reinstate the defendant's bond. I've signed your order to a PR, but the previous conditions are in place, so you need to get yourself back over there on testing.
Yes, Your Honor.
Yeah, would the court consider 2 times a week testing?
Was it one time?
So,
That was my understanding, Your Honor, previously 1 time a week, and we have no objection to that.
and there's one other bond issue people would like to address for court's prepared.
Go ahead.
The victim is the defendant's father, and he is present. He let our office know he would be fine if the no contact order and the no go to was removed. Of course, I'm not in favor of that at this time. Would ask the court to consider it perhaps after the PSI is complete. But in the interest of candor to the court, I did tell defense counsel saying that is something that he would be fine with. And I think it's the defendant's wish as well.
That is, everything Ms. Feltes stated is correct, Your Honor, and she did let me know ahead of time. My client would like to have contact with his father, but we understand the concerns, would leave it to the court's discretion.
Young man, how do you end up in this situation?
Just drugs. Bad judgment.
Yeah. And the person that you threatened with the knife,
My own father.
yeah, and he still wants to have contact with you.
That's kind of why.
I don't know if you deserve it. Honest with you.
I don't think I do either, Your Honor. Sorry. I think so.
And it will increase the defendant's testing 2 times per testing at community corrections. You understand that?
Yes, Your Honor.
I understand the people's concern, and normally it's what I would do. I'm going to give you a shot. I don't know why. I probably shouldn't. I'm going to delete the no go to and no contact or add a provision of no non-consensual contact. You understand what that means?
Yes, Your Honor.
That I'm going to let you have contact with your dad, but if your dad says he doesn't want to have contact, you better find someplace else to be.
I understand
Hear
your.
me? All right. Anything further?
No, Your Honor, thank you.
Who did that?
May not look like the chair.
Wants a no contest plea,
He said pretty pleased with the cherry.
but he did not get that 2
Provided
weeks
to
beforehand. Beg,
Yes,
he did.
yes.
Grovel,
Uh-huh.
he did.
Mhm.
Begged and grovel, not doing it. Let me, don't worry
Yes.
about it yet. Let
No,
me
I did
go
not.
back.
Okay.
We got anything else?
Everything else is holding minus one, which I don't have an update on for Miss Senda.
Which one is that? This one.
Oh, Ray Wilson. Yeah.
Okay.
Yeah, she's right. Other than.
No,
that,
she's
we have
just
three
kicked back in the corner. Okay. Okay, let me go review this so I can then take this plea that has been sprung on me. And then we have a plea form.
Yes.
Oh, we do. Okay. And then let's try to sort out how many
So that's 3 holding.
there are 3 holding. All right, let's figure out who's going to agrees to complete accountable choices, anger management classes, a mental health assessment, and follow all recommendations. There's 2 years of probation with no early discharge. There's also an agreement to there's a sentencing agreement to sentencing under 7694A. That's the court's full understanding.
That is our correct understanding of the offer as well, Your Honor. Mr.
I'm fitting it, Ms. Senda. That's my understanding is going on.
All right,
Miller, is that your correct understanding of the offer?
That is correct, Your Honor.
all right, may I have him sworn?
Right here. You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth shall be God.
Yes. Ethan Miller.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated domestic violence. That is a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. You should first of all understand that it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes.
Based on our conversation? Do you understand that based on the conversation we had in the back?
Not completely.
That passed on the charges.
Yeah. Yes, that is correct, Your Honor.
You also understand that the court is going to treat you the same as though you had, for the purposes of sentencing, the court's going to treat you the same as though you had pled guilty. You understand that?
That is correct. Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Freshour in the 14A3 District Court.
I understand.
All right. Basis for the no contest plea.
Fear of potential civil liability, Your Honor.
Sir, to the charge of aggravated domestic violence, how do you plead?
No contest.
Now you understand that by pleading no contest, you'll not have a trial of any kind.
That is correct.
All right. You signed an advice of rights form, is that correct?
Remember this form that
That is correct. Yes.
All right. Do you have any question regarding any of those rights?
No, I do not, Your Honor.
All right. Look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
That is correct.
You understand you're giving up your right to appeal of right.
That is correct.
Are you on probation or parole?
No.
Anybody promised you anything other than what's been stated here today to get you?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily
That is correct.
and of your own free will.
Yes.
Court has been provided Michigan Department of State Police report for their case number 5992-26. Any objection to the court having reviewed that?
No, Your Honor.
No objection.
Want a review of that report, the court does find that there's a sufficient factual which the court could determine a defendant's guilt to this offense. Sir, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined by the Michigan court rules, the court would no longer be bound by any sentence evaluation and recommendation, and you could not withdraw your plea. Understood?
That is correct.
All right. Counselor, are you aware of any other promises, threats, other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
Have I complied with the
People are satisfied.
Satisfied, Your Honor.
court will accept the defendant's no contest plea to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
September 24th at 1 a.m. or 1 p.m.
September 24th, 2026. What time?
1 p.m.
1 p.m. That's before Judge Fresh Hour.
And that's
Yes, at 14A3. It's actually going to be 14A4,
Very good.
apparently.
so I cross that off.
Sure.
That's your address.
Okay.
All right.
It's gonna be 14.
Bond will continue.
All right. Here you go. Okay. And you were all set.
Thank you.
Right. Yeah.
Thank you. Court does call the case, People versus Warren Abbott.
Anyone on behalf of the people? Brian Bowling on behalf of Mr. Abbott, Your Honor. Take one. Over here, to see it. Yeah.
Thank you.
Your Honor, this is date and time set for the preliminary examinations. People are ready to proceed. At my OIC and my first witness in the courtroom, the rest of my witnesses are in the hallway.
We're ready to proceed as well, Judge.
All right, I'll order witnesses sequestered. OIC may remain in the courtroom as well as the defendant. All right.
Your Honor, the people would call Genia Akhmedova.
Please come forward and be sworn.
Before you take my hand. Solemnly swear upon the testimony you about to give will be the truth, the whole truth, and nothing but the truth. So help me God. See. State and spell your first and last name for the record.
Evgenia Akhmedova.
Yes, please spell it.
EVGENIYA. Last name AKHMED.
Right. One.
Thank you, ma'am. Where do you live?
Apartment 2 of 502 Biscuit Street in Ann Arbor.
And that's here in Washtenaw County. And do you recall back on approximately May 10th, an incident occurring in your apartment that had you call 911?
Yes.
Could you please describe to the court what started that incident?
Yes, it was in the middle of night at about just past 4 a.m. I woke up because of someone being in my apartment, in my kitchen, and then the person approached me. I recognized that it wasn't my neighbor, anyone I knew, and I started screaming. The person tried to cover my mouth. Unsuccessfully, I continued screaming, and then a few minutes later, the person ran away, and I immediately called 911.
Okay. Could you please describe the layout of your apartment?
It's a hallway that opens up to the bedroom. That's it, and it has 2 entrances.
one from East Kingston Street into the bedroom and the other one from the backyard into the hallway.
So it's front door, bedroom, and then what's the next room after the bedroom?
The hallway.
Okay, and is that also like a kitchen hallway combination? And then the back door faces which direction?
The apartment is perpendicular
The-
to the Kingston Street.
Okay,
That door faces the backyard and then goes to the next apartment.
okay. So when you first noticed, well, let me ask this, do you live with anybody? Okay. And did you give anybody permission to come into your apartment at 4 a.m. that day? Okay. When you first realized you weren't alone in your apartment, what did you notice? Where was this person?
He was coming from the kitchen or hallway evening, and I had my siblings with a grow light in the kitchen, so I saw the silhouette, but not the person, and I recognized that, but it wasn't my neighbor who could enter in case of emergency because the person was much taller than my neighbor.
Okay. Is your neighbor short, average height? Okay. Was your door open when you went to bed, or was it closed? Was it locked? Okay. And was the door open when you saw the person in the kitchen, or were you able to notice that? Okay. So you saw the person in the kitchen area, and then you said you screamed?
Yeah.
And what happened when you screamed?
The person walked up to the bed, climbed onto the bed and tried to cover my mouth.
Okay. And did he actually physically touch you?
Yes.
I'm saying he. Did you know what the gender of this person?
Soon because in above the side and the side of the bed. But they hadn't covered but my whole thing.
Okay. So you believe it was a male just based on the circumstances? What else can you describe about this person that you can remember?
See the person because it was very dark and I have terrible eyesight. I only remember the smell, kind of strong body odor and a bit of cigarette smell, but nothing much.
Okay. And so you kept screaming, I believe you testified, and this person eventually ran out. Which direction did they run out of your apartment?
Towards the backyard, so from the back door.
Okay. And a silly question, you never gave that person permission to touch you or in that manner? Okay. I have no further questions at this time, Aaron.
Cross-examination.
Thank you, Judge.
I'm not going to try to pronounce your last name. I'll butcher it. So I apologize, ma'am. My name is Brian Bowling. I represent the defendant in this case. Just a couple of questions for you. Just to be clear, the police arrived to your apartment that evening, correct?
Yes, about 6 minutes after my call.
Okay, and you spoke to them? And you weren't able to provide any identifying information about the person that was in your apartment that evening, correct? And you testified that the person ran out of what you call the back door of your residence, correct? Okay.
So not in the direction of East Kingston.
Okay. And going out, exiting that door, where does it put you if you leave that door?
Then the only exit that is not to Kingston Street is to the street right next to it towards downtown. So it's a parking lot of an apartment building and then the street.
Okay. Is the yard fenced?
Yeah.
Okay. So there would be nothing preventing somebody from going around the house back towards Kingsley Street, is that correct?
Yes, or towards the other street, both times.
Okay. And did you, after the person left your apartment, did you follow them outside? So you have no idea where they went after they left your apartment, is that correct?
I believe I would have heard them going towards East Kingsley because my windows from my bed go directly onto the driveway that leads to East Kingsley.
Okay, but I'll ask my question again. You do not know where they went after they left your apartment, correct? Okay, I have nothing further. Thank you, Your Honor.
Right, any redirect?
No, thank you.
Ma'am, you may step down. Thank you. We call your next witness.
You'll call Officer Raymond.
Why?
Thanks.
Please come forward and be sworn.
What it says, secret in my hand, son, on the testimony about to give you the truth, the whole truth, and nothing but the truth. So, thanks for your first and last name, please.
Officer Y Raymond, WYATP RAY.
All right, you may inquire.
Officer, what's your occupation? And how long have you been a law enforcement officer? And with which agency? And were you working in that capacity back on May 10th of this year? And were you dispatched or had reason to go to an incident occurring at 502 East Kingsley? And do you recall approximately what time you were dispatched to that location? Oh, okay. And what information did you receive as you were responding to the scene?
Individual possibly broken into a residence, had contact with the victim, and then that the individual had fled.
Okay. Did you notice any signs of forced entry? Okay. And the person, was the person you made contact with, Miss Akhmedova? And did you get her statement?
Yes.
What did you next do after making contact with the victim and assessing the scene?
After assessing the scene, I came to see evidence.
Okay. Did you locate any potential evidence during your scene canvass? And what was that? Okay. And where were these brown boots located?
Side 595 East Kingsley.
And is that where in relation to the victim's unit is that?
Apartment complex just to the south.
Okay. Just for was it 515 East Lawrence or Kingsley? Do you know? Oh, okay. Well, Kingsley is the unit that the victim's apartment, the street that the victim's apartment is on. Is that correct? And 515, where you located the boots was towards the other street that runs.
Dane.
All right, sorry, I apologize. So in which direction, if you can, cardinal direction, did you find the boots located? Okay. And do you know which direction Kingsley runs, north, south, east, west? Okay. I'm going to show you what's been previously marked as People's Exhibit 1 and previously shown to defense counsel.
Yes, sir.
Officer, do you recognize People's 1?
Yes.
And what do you recognize it to be? Okay. And does that picture fair and accurately depict the boots as you found them? Did you have any contact with Warren Abbott in this case? Okay. So in terms of your involvement, it was just making contact with the victim and the scene canvas and the recovery of these boots? Okay. People move to enter Exhibit 1 at this time.
Objection or order. Exhibit 1 is admitted.
No further questions, Your Honor.
Officer Raymond, how are you today? I'm well, thank you. Okay, so just to clear up a couple things that I'm confused about. Where did you find these boots?
There's a apartment complex directly to the south of the victim's residence, and the boots were located just on the east side of that complex.
Okay.
Of the building.
How far away is that from the complaining witnesses location? Okay. And did you do anything further after finding those boots in an attempt to determine who they belong to?
Check the area, but there wasn't really anything more for us to do other than the boots, the apartment complex. Really wearing.
Okay, but I mean, I'm assuming you continue to work other shifts, correct?
Yes.
Okay. Did you ever go back to the apartment complex where the boots were found to interview anybody as to whether or not they were theirs? Do you know if anybody ever did that?
I'm not sure.
Okay. Did you do any testing of those boots to determine whether or not there was any sort of identifying information on the boots that belonged to Mr. Abbott?
No.
Okay. So we sit here right now, it's fair to say you have no idea who those boots belong to. Okay. I have nothing further. Thank you, Judge.
No redirect, Your Honor.
Sorry.
Call my
All
next
right,
witness.
thank you, Pops. You call your next witness.
Sergeant Alexander Leathers.
Sir, please come forward to be sworn.
Take a seat, raise your right hand. You solemnly swear to the testimony about to give be the truth, the whole truth, and nothing but the truth, so help you God. Whatever, see. State spell your first and last name for the record.
First name Alexander, last name Leathers, Leathers.
Sergeant, what is your occupation?
Sergeant with the Ann Arbor Police Department.
How long have you been a law enforcement officer? And were you working in that capacity back in the, I guess, early morning hours of May 10th of this year? And did you have reason to respond to an incident occurring at 502 East Kingsley?
Yes.
How did that information come to you and what caused you to respond?
It was a dispatch call, so it came through Metro Dispatch. I was in my patrol vehicle at the time. I was not on anything, so when I heard the call from dispatch, I just self-dispatched myself. I was in the area, within a mile away.
Okay. And what time was this, if you recall?
This dispatch call was at 4:40 in the morning. I had showed up in the area and put myself on scene about 4:41.
When you say put yourself on scene, what did you do?
I got on the radio, let them know that I was in the area and that I'd be BOLing.
Okay. Did you position yourself somewhere in the area?
Yeah, so I stationed myself at North Division and Catherine Street. From what I remember, based off the information, the suspect had already left the area where it happened on Kingsley, and it was unknown which direction he went. So with the hopes that essentially just I was a few blocks away, I just thought I'd stop there in case I saw anybody coming out.
Okay. And is there a building at that location, Catherine and North Division? Okay. And just to get a road layout, North Division runs north-south, is that correct?
At that, the one way, just one more.
Okay. That's right. And then Kingsley, where in relation is Kingsley, 502 Kingsley to where you positioned yourself outside the church?
Approximately a block and a half to 2 blocks north.
Okay. And Kingsley, does that run north, south, east, west? Okay. So it's perpendicular to Division Street. And is there a street between Catherine and Kingsley, if you know?
Top of my head, I'd have to look up.
Okay, no worries. Did you see anyone out at this time at 4:40 in the morning? Okay. As you stationed yourself at the church, did you encounter anyone at that location?
So, as I said, I did not encounter anyone at the church until I noticed the subject walk out from that area. Then, yes, I made contact with someone on the road.
Specifically, when you say walk out of the area, what area are you referring to?
He just popped out of the St. Andrews area. So, on the south end of the building on Catherine Street, they kind of have a staircase there from a door. From where I was stationed in the intersection of Division and Catherine, I couldn't make out exactly where that person walked out from, but it was definitely from that area of St. Andrews Church on Catherine Street.
Okay.
On the side of the street.
And it would be fair to describe this as he was walking away from the location of the dispatch call. Is that correct?
Oh, correct.
Would he be walking towards or away from the dispatch call location?
At the moment when I saw him, it's supposed to think he's walking away from that area.
Okay. And do you see the person you encountered in this courtroom here today? Could you please identify him for the court? In terms of what he's wearing and where he's sitting in the courtroom?
Right now, sitting at the desk right there in an orange jumpsuit.
Okay. And were you able to ID him? Did you make contact with this suspect? Subject, I guess, at this point. And what did he give you his name?
Yeah.
And what was that?
Warren Abbott.
And did he give you an explanation for why he was in the area?
He gave me multiple explanations. Essentially, he told me he was on a walk, he was smoking a cigarette at the church. I asked him where he got a cigarette, gave contradicting statements about that. I believe he told me he was at a frat house, then he said he friends, but he was in the area smoking a cigarette at the time.
Would you describe his story as consistent or inconsistent? And then was he actively smoking a cigarette when you saw him?
100%.
And approximately how long after the dispatch call out did you see him walking on those steps by the church? Okay. While you were out in this area, how long do you think you were at that area in total that day, that morning?
From the time that I showed up on scene, called myself out, after making contact, it's hard to say that 15, 20 minutes, but I can tell you.
Okay.
Tired.
You see any other foot pedestrians at that time?
No.
Okay. And when you made contact with Mr. Abbott, what was he wearing to the best of your recollection?
Gray sweatpants. Remember, he had no shoes on, and a yellow shirt.
Okay. Did he have socks? Do you recall that?
Best of my knowledge, no.
Okay. And yellow shirt, gray sweatpants, you said? Okay. At that point, was Mr. Abbott taken into custody?
He was detained at the time.
Okay. Was he eventually released or was he arrested at the scene?
Eventually.
And why was he released?
Time. We couldn't tell just based off everything we had at the time, evidence-wise. Comfortable not taking him back to the station.
Okay, that's fair. And this all occurred in the city of Anna, Washington, is that correct? No further questions, Your Honor.
Cross-examination. Thank you. Sergeant,
testified that, or Abbott, when you accounted him, was wearing a yellow. Was he wearing any other clothing on the top of his body? Okay. Was he wearing a shirt underneath the yellow shirt? Okay. Was there any identifying information, anything written on the yellow shirt?
Oh, it's a
Okay. Did you testified you don't remember whether or not he was wearing socks?
yeah, oh,
How far is it from the complaining witness's location to where you first encountered Mr. Abbott?
approximately a block and a half.
Okay. And the church property, I guess describe that for me. Where you were sitting, is that the front entrance to the church?
So I would have been at the southwest area of the church, where that intersection is, southwest area of it. They have numerous entrances. One main entrance is off the west end of it. There's another just off the south of it. Get out of station at that intersection, which is the southwest of the church.
Okay. And where did you first see Mr. Abbott?
He was on the south end of the church there on Catherine Street. So, and then again, from where I was, I wouldn't be able to tell you exactly where he'd come out from.
That's not what I asked you. I just asked you where he was when you first saw him.
North side of Catherine Street, just south of the church.
Okay. And was he standing there? Was he walking down the street? What was he doing?
So,
Okay. Down the sidewalk?
uh,
Did you do anything to attempt to, or move to strike? Did you do any further investigation besides your interaction with Mr. Abbott with respect to this incident? What'd you do?
well, following up with the officers that were on scene, trying to connect what they had been talking about, the victim on scene. So I was really just making contact with the officers, trying to gather a full picture.
Okay. Did you do any looking for any items that might have been discarded?
Myself, no, I had officers on scene doing it.
Okay. That's all I have at this time.
Read your.
Your Honor, I did think I neglected to ask that the record reflect the in-court identification, if that could be done, please, Your Honor.
No objection to that.
With that objection, record show so reflect.
No redirect at this time, Your Honor.
All right, thank you. Thank you, sir. You may step. Oh, your next witness.
People would call Officer Mills.
So come forward and be sworn.
Showing from the testimony from your true. Please, last name.
Andrew Mills, ANDREW.
All right, you may inquire.
Officer, what is your occupation? And how long have you been a law enforcement officer? And is that with the Ann Arbor Police Department? And were you working in that capacity back on May 10th? And at around 4:40 in the morning, did you have reason to be dispatched to 502 East Kingsley?
Right.
And what was the nature of that call? Okay. What did you do upon being dispatched?
So when I was dispatched, I made my way from downtown Ann Arbor to the Kingsley location. At first, we were searching for a subject in the area. Searching the area, and at one point I was setting a perimeter make sure the subject stayed within, meeting area.
Okay. At any point, did a fellow officer have a subject detained? And who is that?
Sorry.
Okay. Did you respond to Sergeant Leather's location to see the subject he had detained? And were you able to identify, did you learn the identity of that suspect?
I did.
And what was the name?
Mr.
Warren Abbott is the defendant in this case.
Dang.
Do you see the person that Sergeant Leathers had detained in this courtroom here today? And where do you see him seated or standing? And what is he wearing?
Orange.
And Your Honor, for the record, can please reflect that this witness is to identify the defendant.
Without objection, record shows so reflect.
Had you ever had any contact with Mr. Abbott prior to seeing him detained by Sergeant Leathers?
I did. It was actually the May 9th, earlier that night at around 11.
And what was the nature of that contact?
So I got dispatched to a disorderly area, Huron Street and Ashley Street. It was the parking lot there. Yelling at passersby in the parking lot. As I was looking in the area, saw Mr. Abbott standing on South First Street, wearing a blue flannel, a yellow beanie hat, and gray sweatpants.
Okay. Your Honor, may I approach with what's been previous? Oh, I apologize.
Hold for 1 moment. Just. Wow. Yes.
15 minutes.
Tell me you can have all of them then. No. Go ahead, Ken.
Your Honor, may I approach this witness with People's Exhibit 2, which is previously shown to defense counsel?
Yes.
May I approach? Officer Mills, do you recognize People's Exhibit 2? And what do you recognize it to be?
Abbott, on South First Street where
So does this photograph accurately depict how you saw Mr. Abbott earlier in that night? And for record purposes, or the people who moved to enter People's Exhibit 2 into evidence?
Any objection or one here?
I don't know that the foundation's been properly laid at this point in time as to where that photograph came from, what it is. So I would object to it at the submission at this point.
I'd agree. So go ahead.
Where do you believe this video or this photograph came from?
Fine.
So it's a still shot of a worn body cam? And is that your body cam or did you have a fellow officer with you? Okay. And does it accurately show how you viewed and the video captured Mr. Abbott earlier that evening? People would once again move to enter Exhibit 2.
No objection based on that.
Exhibit 2 is admitted.
Okay. For transcript purposes, could you please describe the attire Mr. Abbott is wearing in that photograph?
It appeared to be a dark colored flannel, is holding a yellow beanie hat, wearing gray sweatpants and dark colored shoes.
Okay. And did you, I forget if you said this earlier, did you immediately recognize the person that Sergeant Leathers had detained as the person you had seen earlier? Okay. Did you have further involvement in this case?
Just upon looking for maybe tossed clothing in the area, that's
And you didn't find any, is that correct? And at that time, was Mr. Abbott released or arrested on the scene?
Upon looking for the clothing, he was.
Okay. I have no further questions, Your Honor.
Cross-examination.
Officer Mills, this individual that's depicted in that photograph, where did you see that person?
To the South First Street.
Oh, okay. You didn't say at Huron Street and Ashley Street?
So that's where we're originally dispatched. We're looking at the immediate area, which South First Street parallels the street, and that's where I found.
Okay. And what was that person doing at that time?
Against the lawsuit.
Did you have any interaction with him at that time?
I asked if he heard any person yelling in the immediate area, and he said no.
Okay. Did you have an opportunity to speak to him when you went to where Sergeant Leathers was located? And you testified that you did a search for items in the area of the complaining witness's location for this incident? Okay, and you didn't find anything at that time, correct? Okay. How long did you search?
I can't say.
Okay. Did you ever respond to the complaining witness's location?
I searched in the back of the residence, but I didn't speak to the caller.
Okay. And you didn't find anything back there?
Not behind the residence.
Okay. And you did not find any individuals at that location that may have been a subject of a crime or anything along those lines, correct? Okay. I have nothing further. It's my time, Your Honor.
You direct.
No, thank you, Your Honor.
All right. Thank you, sir. You may step down. Thank you.
Yes.
Third chair.
Sir,
Yes.
the people called Detective Detroiter. And I will need to play a video briefly during this testimony. Do I just plug this HDMI cable into mine? Okay, I'll let you know when I'm ready to do that.
No, I'm sorry. Yes. Maybe sworn.
So I'm swearing from the testimony about to give you. All you.
I do.
Thanks for your first and last name, correct?
Sophie Detroyer, Sophie. Detroyer is Detroyer.
All right. You may inquire.
Detective, what's your occupation
Department.
and how long have you been a law enforcement officer? And were you working as a detective back on the early morning hours of May 10th?
I was employed as such, but I was at home.
Okay. Did you have any reason to become involved into the investigation of a potential home invasion occurring at 502 East Kingsley that morning?
Yeah, I was assigned an officer in charge.
Okay. So when you were assigned, what steps did you take in investigating this case?
I originally reviewed the report that was inputted from the other officers that we've spoken to. I found the body cam footage from Officer Miller's body cam that described the other suspect that he had seen earlier that day. I also reached out to, I went to the victim's house and I spoke with her. I canvassed the area around the place and tried to find surveillance footage. I did find surveillance cameras and I contacted the housing complex that had the surveillance cameras.
So just to get the layout down, 502 East Kingsley is on Kingsley Street, is that correct? And where did you find video cameras in relation to that address?
Just south of 502 East Kingsley is 515 Lawrence Street. The two backyards butt up against each other. 515 Lawrence has a bit of a raised parking lot, and it's an open parking lot, and they have a camera that use the parking lot and a bit of back there on 502 East.
And the address is on the next street over. Is that what you said? When you encountered with Mr. Abbott, did you notice any body odor at all?
I encounter a lot of people that sometimes have different levels of body odor.
Okay, but you could smell some sort of odor coming from Mr. Abbott's person. Okay, I have.
But you don't encounter him till the next day or that night?
It was the next day.
Okay, no further questions here.
All right. Anything else? No. Thank you, Detective. We step back.
Judge, my final witness will be Officer Marks. And Judge, just as a testimony, I did realize that I am asking the court to amend the complaint or information, as I believe the RNO actually occurred on the Monday, 5/11. So I'd ask for a date range of 5/10 to 5/11 to be amended.
I would not object to that for the purposes of this.
You are, or
I'm not.
not? Okay.
That is it.
So I'm sure from the testimony about to give you the truth, the whole truth, and nothing but the truth. So, I didn't. So your first left hand. Officer Keandre Marks, KEIANDRE. Last name is Marks, MARKS.
Main point.
Officer Marks, you're an officer with the Ann Arbor Police Department. And how long have you been a law enforcement officer? And were you working on May 11th as a police officer for Ann Arbor? And were you given some task in relation to a Mr. Warren Abbott that was in AAPD custody?
Yes.
And what was that task?
Transporting to
And where was he when at the time you were given this task? And that's in downtown Ann Arbor. Okay. So what did you do in terms of transporting him to the jail?
Well, first went back there to okay. And then essentially, once we got him into custody, put him in the car, transported to the jail.
Okay. Did any incidents occur while transporting him?
Yeah.
Could you please describe that to the court?
First incident was when he was on the walls. He stated that he was homicidal and suicidal and wanted to go to hospital.
Okay.
Once we learned that we were going to take him into custody, and he said, "Am I allowed to be explicit?"
Yeah.
He said, "Y'all have to not touch me. I'll fuck y'all up."
And who's he talking to when he said this?
There was well at that point.
Okay. And were you all in uniform? Okay. And you specifically, could you describe the uniform you were wearing to the court?
Sure.
Does it have AAPD on there somewhere? Okay. And what occurred after he made that statement?
After he made that statement, we were able to take him into custody. Basically, we were able to de-escalate the situation. I transferred him to the elevators. He fit forward once, and then after that, I was going to press the elevator button. He spit on my right arm, and then he stated, "I'll spit in your face."
Okay. So where are you in relation to Mr. Abbott?
I'm on the right side.
Okay. And do you see Mr. Abbott in this courtroom?
Yes.
Please tell the court where he's located in this courtroom and what he's wearing.
Jumpsuit.
And Your Honor, may the record please reflect that this witness has identified the defendant.
Okay, so we're like.
And so you're to his right side, and you said he spat forward,
Yes.
and then he spat on your arm. How did he have to turn himself to spit on your arm, or?
I was reaching. But
Okay. From where he was standing, would he have been able to see your arm moving across him towards the elevator button?
yes.
Okay. after, and then he said, I'll spit in your face. What occurred on the transport after that?
Once we got into the elevator, we were able to get him in my patrol vehicle. I transported him to the U of M. On the ride, I made sure that we had additional officers from U of M and hospital staff. Once we got to U of M, he was very uncooperative and began to spit some more. And we finally got him on the bed he transported at the time.
Okay. Did you use a spit mask or attempt to?
We attempted to. And we were unable to at first originally because the way his hair is.
Okay. And when he was spitting later on in the transport, did that hit anybody or did he threaten to try to spit on anyone individually? Okay. But as far as you know, you're the person who got hit with a spit.
Yes.
Okay. And this occurred in your building in Ann Arbor. That's when you were struck with a spit?
The first incident with the spit, yes.
Okay. All right. I have no further questions, Your Honor.
Examination.
Real quickly. When you were moving him from, I guess, the holding cell to the elevator, as you just testified to, was he saying anything?
I don't know what he.
Okay, but was he talking? Whether you recall what he said or not, was he talking? Was he screaming? Okay. How far was he right next to you when you went to push the door of the elevator or the button of the elevator? Okay. Yeah, how far away?
And I was holding on to.
Okay.
With my left hand and reaching.
So you were holding on to his, what I guess would probably be left arm, or his right arm. I'm sorry, with your left hand.
Yes.
Okay. And were there other officers there?
Yes.
Where were they in relation to you?
His left arm. As far as Officer Raymond and Officer Moore, I'm not.
Okay. Was Mr. Abbott walking?
Yes.
Okay. Was he walking voluntarily?
Yes.
Okay. Going back to when you were trying to take him out of the cell, did you attempt to put handcuffs on him at that time?
Originally he said, we have to not, touch him or else he will focus on. And then Sergeant Beaufort employed some de-escalation, just kind of talked to him in order for him to comply to.
And he allowed you to put handcuffs on, correct? Okay. Did you actually apply the handcuffs to him?
Yes.
Okay. And was he in handcuffs the entire time to the hospital?
Yes.
Okay. He was in the backseat of the vehicle by himself?
Yes.
Okay. Was he doing anything in the vehicle?
He was laying on.
Okay. Saying anything at that point in time? Oh, okay. You said you got to the hospital, correct? And at that point in time, some individuals come out of the hospital. How long did that take before you were in the hospital?
I couldn't say probably 5 minutes, maybe less.
Fair enough. Okay. For this purpose, that's all I have at this.
You redirect.
I just do want to clarify, Your Honor. So you described the spit forward, then the spit that hits your arm. Was this spit flying out of his mouth while he was talking, or did you believe this was intentional? And what made you believe that?
Well, originally the statement that
Okay. And was there any noises consistent with a spitting? Okay. I have no further redirect, Your Honor.
Did he spit in your face?
he did not.
No, further finish.
Thank you. You may step down. Thank you, sir.
Your Honor, at this time, I have no further witness or evidence. Rest.
No witness.
All right. No motion.
Your Honor, people move to bind over on both counts 1 and 2. Happy to go into probable cause.
Go into one thing. How do I connect that person in the video to Mr. Abbott?
Yes, Your Honor. So that would be through Officer Mills' testimony, who says that he encountered Mr. Abbott earlier in that evening, as well as on the scene where Sergeant Leathers had him detained, recognized them to be in the same person.
Sergeant Leathers?
Sergeant Leathers.
Yeah, go ahead.
And Officer Mills then testified that People's Exhibit 2 accurately reflects what Mr. Abbott was wearing earlier that evening, which he described as a plaid shirt, a gray sweatpants. You can see dark colored, what I'd submit as brown shoes, white socks, and holding what appears to be a yellow cap. In People's Exhibit 2, in People's Exhibit 3, Detective Detroyer also described what she observed on the video, and the court could review it for itself. The individual does appear to be wearing some sort of plaid shirt, gray sweatpants, and white socks, as well as a yellow hat. When Sergeant Leathers encounters him, and this is just approximately 3-4 minutes after the 911 call, in the same area, in the same direction of travel that the victim testified the person left her house from. He is shoeless, wearing gray sweatpants and a maize shirt, no longer wearing a flannel or
I get that.
any shoes.
But the flannel was never recovered anywhere.
That's correct, Your Honor.
And also, at least my notes reflect that Sergeant Leathers, he didn't have shoes or socks.
That's correct.
So I guess, and I'll just get to the point. So 3 or 4 minutes afterwards, the individual is dressed differently, particularly with reference to his socks. And also his top, whatever he had on. And then he's headed in a particular direction, but this is just 3 or 4 minutes. And they canvass the area not only that night, but the next day, and nobody locates any of those clothing items.
That's correct, Your Honor. The shoes were located in the area. The subject on film obviously is in socks. So I would submit that the person may have taken off the shoes before they committed the home invasion, and then fled wearing socks, and then discarded the socks and flannel and kept the gray sweatpants on. I would also note that the victim testified that, as well as the body odor, she smelled cigarettes. Your Honor, Mr. Abbott was seen smoking.
I could downtown Ann Arbor and find you 10 people in a minute that have those characteristics.
At 4:40 a.m. within
Probably
a block and a half of and I would note that officers did not see any other pedestrian foot traffic in the area the time they were out. And I would also highlight that Mr. Abbott gave inconsistent statements regarding direction of travel and where he was coming from. I understand it is circumstantial, but given the direction of flight, the time of the morning, the recency, I submit that it is an issue of fact.
What do I know about the shoes?
So the shoes were located, obviously, within yards of the home invasion. We know that we believe we have a video of the person fleeing the home invasion without shoes on.
I know, but what size were the shoes? I mean, I know nothing about the shoes that were found vis-a-vis the shoes that are in that picture. Do I?
Other than color, I would submit not. I would note that Mr. Abbott told the police that he left his shoes at home and that they were also brown in color. And then when a search warrant at his residence was unable to locate any brown shoes.
Oh, that's a whole nother issue with the search warrant. But so what ties him to this are shoes, not descriptive color, but brown shoes, body odor, and they're a smoker.
Well, I think the highlight is how one direction of travel from the crime scene, and the short temporal distance in terms of this is a block and a half away, approximately 3 minutes or so, 3-4 minutes after the 911 call. I would also note that the shoes, I know we don't have exact details of brand or anything like that. However, they are not inconsistent. People's Exhibit 1 and 2 are not inconsistent in terms of being different shoes. They appear that they could well be the same shoes.
So I sent people to trial on could well be.
Well, that's just one factor.
You don't need to answer that. That's
Sure. Your Honor, I submit circumstantially there is enough to say that it's probable cause that Mr. Abbott was the person that entered that house at this time.
all right.
But the people would leave it at that and have no further evidence to present.
Your Honor, I would object to the bind over in count 1. I just don't agree that there's evidence here that places Mr. Abbott anywhere in that residence. Ultimately, the video that we saw here, that person depicted the direction that they're going. My understanding does not put him anywhere near where those shoes may have been found. No further investigation done to determine whether to tie those shoes any further to Mr. Abbott. As far as I know, they belong to somebody that lives in at the property there on Lawrence. I don't remember the specific address off the top of my head. But I don't think the people have met their burden to establish probable cause for count 1. Count 2, based on the testimony of the last officer, I think that the court could bind over on count 2, but I don't think there's been probable cause shown here again for count 1. Thank you.
What do I do with count 2? And maybe the people can explain this. What was the probable cause to take him into custody?
Same probable cause that Your Honor is presented with this morning.
Oh, well, that's going to be a problem.
Obviously, Your Honor, there is case law that states the probable cause for arrest is different than the standard of probable cause to bind over.
I know, but let me ask it this way. Not saying if anybody did anything bad, but if the defendant should never have been in custody, hypothetically speaking, the officers are then transporting, and he is doing something that is a response to what may be an illegal detention, then is he guilty of resisting and obstructing? Because my understanding is I can resist an illegal detention.
That's correct, Your Honor. If you're ruling that the police did not.
I'm not ruling anything.
No, I would.
When I rule, you'll hear me.
I agree, Your Honor. So law is clear that a person may resist an illegal detention. I don't think that is what we have here for the reasons stated. Regardless, Your Honor, these officers are, one, he's now made homicidal, suicidal statement. So I submit they have a duty to petition and take him to the psychiatric hospital. Additionally, Your Honor, they're relying.
But why? I got that, but I'm just saying, why is he there? I mean, because my problem is, and I'll just be blunt about it, my problem is Monday, when it is just stated that there's probable cause to arrest him. I'm trying to figure out what that probable cause is.
Right, so Your Honor, they release him at the scene because they don't have probable cause of that.
Correct.
Right?
So what changed between the time that they released him, because they clearly say they don't have probable cause. What changes between that time and the time that they arrested him?
So they got the surveillance video, Your Honor, shows the subject fleeing from the crime scene, wearing a plaid shirt, wearing a yellow hat, gray sweatpants, and white socks. Your Honor, Officer Mills, then they review his body cam from the earlier encounter that night, and it shows that Mr. Abbott was wearing that exact outfit plus brown shoes. Or in the exhibit 2, he's holding a yellow hat, not wearing it. So, Your Honor, that's why they now have probable cause. They have Mr. Abbott, who just mere hours before the home invasion is wearing essentially exactly what this person who committed the home invasion.
Well, hold it. He's wearing what the person running away from the place is maybe wearing.
If you assume the person running away is the person who committed the home invasion.
Well, okay. I don't know that we make those assumptions necessarily because I think I need proof. And that's okay. Anything further?
Yeah, I would just also that assumption is based on Detective DeToyer's testimony that in the video you see the porch light click on, which is the victim's porch light, and that that's where the subject seen on the video is running from. Additionally, Your Honor, the time this is almost simultaneous with the 911 call.
In the case of the state of Michigan versus Warren Abbott. Any, go ahead, Councilor.
You want us to put it Pierce?
Please.
Zachary Ward on behalf of people.
Brian Bowling on behalf of Mr. Abbott. For Warren Taylor Abbott.
Thank you. All right. Any additional argument?
No, Your Honor.
No.
Court had listened to the testimony in the case, and the court typically, well, during a preliminary examination, there are two things that the court must find. First, that there was a crime committed, and secondly, that the defendant committed the crime. With respect to the home invasion, first degree, as to that second part, that the defendant committed the crime. Well, first of all, I believe that there was a crime committed by the testimony of the victim in the case, but the court doesn't believe that there's sufficient evidence to show that this individual committed that crime. Specifically, so that the record is clear, the defendant was dressed in a particular way. I don't find sufficient once even they get the video and then the photograph that created in any way more probable cause to arrest the defendant for the events that night. Most importantly was the testimony of Sergeant Leathers, that upon coming across the defendant, that there was a yellow shirt and there's a yellow shirt and he has no shoes and no socks. When I look at People's Exhibit 2, I see a yellow hat, but I don't see anything that resembles anything being yellow under that. This clothing wasn't found anywhere. Presumably the defendant or the people's position may be that he discarded certain things, which would have been the sock and the flannel, but none of that was ever located. More importantly, while the shoes look the same, I think you could probably walk into a number of different households and find the same shoe. I don't have anything that even remotely gets the court to the point of saying those shoes that were found at that location are the shoes that the defendant is wearing. Even something as simple as what size. Quite frankly, they had a search warrant to go in his house. Whatever shoes would have been in his house, they could have gotten what shoe size he wears. It says, yes, he wears X shoe size, and these shoes that we located are that size. I don't even have that. So I think with reference to the home invasion, the people have not sustained their burden, and the court is not going to bind the defendant over on count one. As to count two, the question for the court, and it may be something that needs to come up at a later point in time. I don't think that at this point that I can deal with it. So whether or not, given I don't think that there was probable cause to arrest this defendant, I'll state that specifically. I don't think probable cause to arrest existed. I worry, but I have seen what the search is that led them into place. But ultimately, this gentleman gets arrested. I think at the time that the Officer Mark, was, his actions were lawful given the circumstance as he sees them. And therefore the defendant spitting on him. And I agree with actually what Officer Marks indicated, that I think it was intentional doing that. And as such, then I think the defendant did that. He knew they were officers, shouldn't have done it. One could determine, or may have to be determined, whether or not the officers were acting under lawful authority, but I don't know that that's before they are lawfully acting. I don't know that that's before the court today. So for those reasons, I will bind the defendant over to stand trial only as to count two, finding no probable cause as to count one.
I'll submit a amended information with the correct date on it, Your Honor.
Yes, that is correct. Okay. And as to that, do you waive presentation at this time of the?
We do. I will waive presentation. I'll stand mute to the charge for purposes of the circuit court arraignment, Your Honor, and just ask for a pretrial date.
And defendant standing mute, court will enter a not guilty plea as to count two. Pretrial will be set for
October 14th at 1:30 with Judge Conlon.
October 14th, 2026, 1:30 before Judge Conlon. Bond continued. Thank you. What?
This guy having what? Meetings. Okay.
All right. I will specifically call, let's start with Mr. Ray Wilson's case ending in 1081.
As to that case, at this time, the people are going to be unable to receive all charges in that case.
You're moving to dismiss.
Yes, Your Honor.
All right. People being unable to proceed, that case is dismissed on the motion of the defendant. That takes care of that. Then on the case ending in 0783.
At this time, Your Honor, people have unable to proceed as to counts 1, 2, and 3, and would be asking the court to remand on the misdemeanor counts 4 through 8 at this time.
So you are moving to dismiss counts 1 through 3 in this?
Yes, Your Honor.
All right. So on that case, counts 1, 2, and 3 are dismissed. I'll continue the defendant's not guilty plea as to 4, 5, 6, 7, and 8. I will set a pretrial date in this case. This
September 9th at 8:30.
September 9th, 2026, 8:30
Then Your Honor,
for Judge Barr.
as to case 0784, it is the people police that through the testimony today. The probable cause a charge of criminal sexual conduct with first degree lawful and unlawful imprisonment. It's my understanding that Mr. Denowith should and is going to take some time to talk to his client about those.
All right, very good. And I'll pass that matter. So, sir, you can talk with your attorney a little bit more deeply. Thank you. Court calls the case, People versus Jason Sidley.
Good afternoon, Your Honor. Jacob Kennedy on behalf of. Good afternoon, Your Honor. My name is Leslie Trisket, representing Jason Sidley, who will be.
Oh, this is the date and time set for preliminary examination. Your name, sir?
Jason Sidley.
All right, you can have a seat. Counsel approach briefly.
Sure.
Only witnesses, I'm excluding it, so once they get here. Pardon? Right.
They're walking down the hallway now, Your Honor.
The information.
Your Honor, this time the people to call Danielle Messer.
It's locked on me, correct?
Yeah, hold on 1 second, please.
Here we have just a moment, Your Honor. Thank you.
How much time are you gonna need?
Half hour maximum, I think.
Half an hour?
Maximum. I use that.
No, if you need the time, I'll give
Really, if
But if
20 minutes.
that. And what I'm gonna do is,
Oh, I was confused. Mr. Allen's exactly right. I thought you were asking how long the testimony was going to be.
no,
I think
I'm
if-
saying, how much time did you need with her?
I don't know.
Okay, well, here's what I'm gonna do. Everybody can stand down. I'll stand in recess. Let me know and then I'll.
Okay.
Right.
Sorry.
Court does call the case of the People versus Ayed Abulis.
Good morning, Your Honor. I should talk to
Morning.
people.
Morning, on.
It's just dismissed. Zachary Ward on behalf of the people.
And I apologize, Your Honor. Assistant Public Defender Natalie Pate standing in for Miss Apple on behalf of Mr. Alvarez. Sir, can you please state your name for the court?
Thank you.
Your Honor, at this time, the people are unable to proceed on either file.
Motion to dismiss on both matters, Your Honor.
People being unable to proceed these cases are dismissed on defendant's motion. That's without.
Thank
All
you,
right.
Honor.
Thank you, Your Honor.
Court does call the case People versus Timothy Lacey.
Zachary Ward on behalf of the people.
And Assistant Public Defender Natalie Pate with and on behalf of Mr. Lacey, who is approaching the podium. Thank you, Your Honor.
Good morning, Your Honor. Timothy Lacey.
Thank you.
Your Honor, at this time, the people have extended an offer that on a waiver of his preliminary exam, Mr. Lacey can plead under the Homeless Youthful Training Act. In circuit court, with Judge Moon, where he's currently on her fight docket at this time.
That is correct, Your Honor.
All right. So you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Understood.
You understand that you will not have that hearing and that you'll proceed to circuit court for further resolution.
Understood.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on count one with count two following. Ms. Pate.
Thank you, Your Honor. The defense acknowledges receipt of the information. We waive its reading and my client stands mute.
Defendant having waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
October 19th at 1:30 with Judge Committee.
October 19th, 2026, 1:30, Judge Hammoud. Bond will continue. Good luck, young man.
All right, thank you.
Thank you, Your Honor.
Yes.
OTP.
Court does call the case. People versus Ubicio Moreno.
Morning, Your Honor. Raymond.
And good morning, Your Honor, to you and your staff, Attorney Maxwell Dubin, P number 86012, on behalf of Mr. Moreno, who stands to my right. Please state your name for the record.
W. Moreno, Your Honor.
Your Honor, this time the people are unable to proceed. I had communicated with the defense counsel that slightly will be read.
And in light of the prosecutor's information, I would move to dismiss for those reasons alone.
People being unable to proceed, this case is dismissed on defendant's motion without prejudice.
Great to see you guys as always. Have a good rest of your day.
Court does call the case People versus Eric Woods.
Thank you, Your Honor. Alex.
Seriously?
Alex Warren on behalf of Mr. Woods. Apologize. Sorry. Search it. Eric Woods. Your Honor, it's a date and time for preliminary examination. At this time, the defense is ready to proceed. In speaking with the people, my understanding is that they are not.
Yes, sir. I am standing in right now for Ms. Zenda on the Woods matter. She's entering the courtroom, so I'll let her. And then, people, Your Honor, my apologies.
No, not a problem.
You know, today's the date times at the preliminary examination. At this time, the court unable to proceed as to count one of ask the court to remand on counts 2 and 3 of this report.
And the defense would move to dismiss with respect to count 1, Your Honor.
Count 1 is dismissed. I'll continue to defendant's not guilty plea as to counts 2 and 3. Pretrial in this matter will be set for a darn good question. These are city cases.
September 9th at 8:30.
September 9th, 2026, 8:30. Before Judge Barr. Bond, continue.
Thank you, Your Honor.
Sorry. Person's in. Let me do the other one. Court does call the case People versus Damon Cooper.
People. Good morning, Your Honor. Please support Attorney Sharon Jones, number 57113, on behalf of Mr. Cooper, who's approaching.
Morning. What's that?
Oh, sorry about that.
Oh, good morning.
Good morning.
Damon Cooper.
Thank you.
Your Honor, in discussing the case with Detective Sawyering this morning, he let me know that he got some video footage from the hospital, which is very important in this case for reasons we go into if the court would like, but it is important, I believe, in this matter. So I'm requesting an adjournment so I can get that to my office, get a copy to Ms. Jones. I did indicate to her that if this case were to be dismissed today, it would be my intention to refile.
All right.
Your Honor, we're ready and we're requesting a dismissal.
It is what? The 18th. Well, let me just look it this way. I understand your request. If I dismiss it, they reauthorize. I'm not sure when he's going to get back up here and potentially could be rearrested. Or what I can do, just to give you options, I can adjourn it 2 weeks, let you get that. Whatever your option is. Doesn't matter to me. I just wanted to make sure you understood all the options.
I understand, Your Honor.
Still moving to dismiss?
For the record, I believe that, just a moment, Your Honor.
Yes. And counsel, just make sure to push down the button in the front so that we can hold the conversation to hold it though.
Okay.
Miss Karen, the Miss Paid, it brings back memory.
Right.
Just wait.
Sure.
We're objecting, Your Honor.
Pardon?
We're objecting
Objecting.
to the, to an adjournment.
So you'd like it dismissed?
Yes.
People at this time being unable to proceed, this case is dismissed. That's on defendant's motion. That's without prejudice. You understand that, young man?
Yes, sir.
All right. Thank you.
Thank you, Your Honor.
Court calls case People versus Dion.
Morning, Your Honor. Raymond Cook for the people. Assistant Public Defender Ben Denowitz for Mr. Bird, who is joining me at the podium.
Your name, sir?
Yeah, Amber, how you doing?
I'm doing great. Thanks.
Yeah.
Your Honor, we have a waiver in this matter.
Bird, you're waiving your right to a preliminary examination?
Yeah.
And you understand that that's a proceeding where the people would have to show by the standard of probable cause that the offense alleged was committed and that you committed it.
Yep.
You understand that you won't have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right?
Yes, Your Honor. There's actually an offer extended.
Okay, please.
The offer is to waive up on an amended information adding account 2 of resisting obstructing police officer, the 2-year offense. Tax code 750.81D1. Count 1, the resisting obstructing and causing injury would be dismissed at the time of the waiver. I do have an amended information prepared. I have defense counsel. I can approach to hand that to the board.
Is it true that people are also foregoing a habitual offender notice?
It's also free.
Is that my copy?
Okay, so
Write your date.
see how we're gonna do this, because it's count 1, it's count 2. All right, let's, as to the amended time,
We will stand mute, waive the formal reading. We have us discharge.
Good minute. So what I will then do is I will, understanding that agreement, I'm dismissing count 1. Find the defendant over to stand trial on count 2. As to the
Stand mute, waive the formal reading as to count 2.
defendant every way for reading, standing mute as to count 2. Court will enter a not guilty plea. Pretrial will be set for
August 31st at 1:30 for Judge Hamud.
August 31st, 2026, 1:30, Judge Hamud. Bond.
1:30 p.m.
Thank you.
Thanks, Judge.
Oh, you know, hey, Matt, you're not allowed to break it off.
Yeah.
Okay. So who's ready to? Well, let me get this out of the way, figure it out. Oh, okay, so shoot, doesn't it?
Yeah.
Court does call the case of the people versus Melvin Withers.
And then I have
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Witherspoon. Statement records, please, sir.
Melvin Witherspoon. Yes, sir.
seeing Mr. Witherspoon will be waiting for when you get the children agreement, but people cannot have the children because this is required.
That is our understanding of the agreement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes, sir, Your Honor.
You understand that that's a proceeding where the people would have to prove by the standard of probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir, Your Honor.
Well, also waive their right? Preliminary examination having been waived, defendants bound over to circuit court on counts 1 and 2 with following.
Your Honor, we waive formal reading, stand mute.
Defendant every way formal reading standing mute to all charges. Court will enter not guilty. Trial will be set for
September 2nd at 1:30 with Judge Conlon.
September 2nd, 2026, 1:30 before Judge Conlon.
Your Honor, my client wants me to address bond.
Go ahead.
He's requesting a personal bond on this case. He has holds in other clients or the other counties, excuse me, one in Jackson and one in Lansing. He wants to be able to go resolve them. He doesn't anticipate being out of custody, but he wants the opportunity to go there and
what are for the holds? Because
probation. For Ingham County, individual firehouse with bond denied at Jackson, GBH, DB3rd, integrated electronic communications, where bond is also denied, and I was often need to address his phone privileges today.
And in Lansing, he's on probation.
But he also has a bond denied, so I'm going to deny that request because get before Judge Conlon and he can figure out what to do if he wants him to go someplace else and then have the case rather than that now. All right, as to the people's request.
Came to my attention that Mr. Witherspoon made some jail calls in which he calls third parties and has them create a Snapchat account. That Snapchat account was then used to contact the victim of this case, asking her, what's up? Where's my shit? I'm in Jackson. My phone to come get my shit. Do I need to have Brenda come get it? So I'm concerned that he's reaching out to the victim, telling that you have people come to her house, get his things, and that he's even reaching out to her in the first place. So at this point, I'm going to ask that his phone privileges be revoked from third-party contact. And a sub-report was done on that. I'm not sure if it was sent over yesterday or if it was sent over today as to those.
I did get the report, Your Honor. I don't have the actual call. Mr. Witherspoon wants it to be known that the number for the complainant is blocked. He's having a conversation with his ex-girlfriend. There's a conversation about passwords because he has her log into his email to check some things for work or things like that. His email or something or social media.
Girlfriend was on my phone on my page communicating with the victim. Since I've been here in jail incarcerated, I have not reached out to the victim because the jail blocked her number. So I have not had no contact with the victim at all. But it was a conversation with me and my ex-girlfriend to go get my belongings from her house, just to be honest.
Okay, and that no, I got you, but that's a violation.
Yes, sir. I understand that, Your Honor.
And,
I understand.
Okay.
But like directly to the victim, I can't even call out of the jail to her.
I know. What the people indicated, and that's what I was trying to clarify.
Okay.
Was it wasn't that you contacted directly, it was that there was a third-party contact that you made.
Okay, yes, sir. I understand.
Okay. So at this time, what I'm going to do is I'll revoke the defendant's phone and texting privileges. You can also raise that when you get before Judge Conlon as to whether or not he wishes them restored. Okay. All right. Thank you.
All right, thank you.
All right now.
You may. Well, I can't do it. But yeah. I'll let you. She'll have it. Just like my work. I think I did pretty good. Don't you think so?
Yeah.
Love you guys.
Okay.
We're gonna do the slides.
So are we going to, while I'm waiting on this one, are we going to be ready to go on something soon or? No.
This is case kind of a plea. And then Ms. Foster Tucker and I have an adjournment request. I'm writing up the plea form from Mr. Bellinger's case.
Okay, I'll let you guys do that. Court does call the case, People versus Kristen Reed.
Ashley Feltus with people.
Sherilyn Foster Tucker on behalf of Christian Reed.
Her name?
Christian Reed.
Thank you.
Your Honor, in this case, the officer in charge and basically the sole witness remains on FMLA, is not able to come to court today. The people are requesting an adjournment. I don't think there's going to be an objection from defense counsel. He returns to work September the 7th.
September 7th?
That's correct. That's my understanding.
Okay. Is this the only thing holding him?
Yes, Your Honor, and I do wish to address bond. So this is an adjourned preliminary exam. I was not the prior counsel, but his bond was revoked. I was under the impression that this was a bond violation hearing as well, and we were hoping to address that today. I'm not sure.
I think the court revoked him the last time because he had they tried to contact him.
Community corrections violation.
Right, Your Honor, that's correct.
Okay, I could adjourn this, but R has my 8th. For me, but so what I could do is adjourn this to September 8th for Judge Barr, because we flipped dockets. All right, so I don't think he'll mind that.
No.
So preliminary examination will be adjourned to September 8th, 2026, 9 a.m. before Judge. I'll just put before Judge Barr for me, because he'll have that. As to his bond at this time, given the fact of the community corrections violation and his failure to contact, how, if I were to release him, how am I sure that he's follow instructions, because he didn't, and they're.
Yes, and Your Honor, I have, since I've been on this case and I've spoken to Mr. Reed, I do think that in the past at least 3 weeks that he's been in jail, he's had time to reflect on this. He has indicated to me that he understands completely that the failure to contact community corrections was on him, and that in the future, if there is confusion, then he needs to either go to community corrections or make sure to make contact with someone to resolve that, and not just assume that everything's going to be okay if he isn't able to call them right at the second. And he has expressed to me that he does wish to take accountability for the failure to contact them, and he understands the importance of abiding by those conditions. Additionally, I have, since he's been incarcerated, I've had good contact with his mom, and she remains supportive, and I know she wants to help him with this, although he has indicated to me that he understands he's 18 and not a kid anymore, and that this really is on him. I'm also, because I've had good contact with his mom, I believe that once he is out, I will be able to establish good contact with him and make sure that he's understanding his conditions and assist him with that.
Do people have a position?
I'll leave it in the court's discretion, Your Honor.
Where does he reside when he's out?
Like my house, Heron Heights, 1323 Concourse Drive.
So if I let you out, tell me, what are you supposed to be doing vis-a-vis community corrections?
Contact them every time, all day, every day. Contact whatever y'all want me to, really. Whatever your guidelines is, whatever you want me to do, it will be done.
I don't know if I believe him. Maybe I believe him. It's Foster Tucker that's giving me everything. I'm on 929. So what I will do is, since the defendant is admitting to the violation, I'll sentence him to 21 days in jail, credit 21 that he served. As to the bond, I will grant the motion of the defendant. I'll reinstate this previous bond with the conditions. In light of that, won't be rushing necessarily to get to the exam on the 8th. I'll set the exam for September 29th, my next day.
Oh, very good, Your Honor.
Okay, before me. And since it's coming back for me, I dare you not to keep in contact. Hear me?
Yes, sir.
All right, thank you.
You too.
Always a pleasure.
29.
29.
Thank you, Your Honor.
What? Don't, he's holding his hands up like he just want to, you know what? That was to who? Where's mom?
That's
Okay, he was raising his hands toward his mom. All right, that's okay. I'll let that go. All right. Court calls the case, People versus Alexis Baker.
Zachary Ward on behalf of the people.
Your Honor, my client's in the hallway. I will retrieve her immediately.
Oh, thank you, Hannah. Yeah, Hannah was halfway there by the time you even turned.
I didn't want to delay anything, Judge.
What'd you say?
I didn't want to delay anything, Judge. I was ready to run.
Right.
Alex Warren Green on behalf of Miss Baker. Miss Baker, can you state your name?
Alexis Baker.
Thank you.
Your Honor, after talking to the victim this morning, the people are not inclined to proceed on count 1. We'd ask that count 2 be remanded to 15.
And the defense would move to dismiss count 1, Your Honor. We'd stand mute to count 2.
I'll continue the defendant's not guilty plea to count 2. Count 1 is dismissed. Set a pretrial date in this matter for
September 9th at 8:30 with Judge Perry.
September 9th, 2026, 8:30 before Judge Perry. Bond continued.
Okay.
Thank you.
Thank you, Your Honor.
Excellent.
Yeah.
Bring him, let's please.
They got him. Court does call the case of People versus Hunter Hallis.
People.
And Assistant Public Defender Natalie Pate with on behalf of Mr. Hallis, who is approaching.
In this courtroom session, 2 very different defendants appeared before the judge, and both cases showed how the court can focus not only on punishment, but also on rehabilitation and second chances. First was Keith Johnson, who appeared for a status conference with his attorney appearing by video. His lawyer explained that they had not yet had the opportunity to fully review all of the discovery together. Johnson was reportedly prepared to accept that offer, but there were important conditions attached. Before the case could be resolved, he would need to complete an alcohol treatment course and write an apology letter. If he completed those requirements, the case could potentially be resolved as a misdemeanor with costs only. The judge made sure everyone understood the plan and gave Johnson time to contact the program and complete the required courses. A tentative plea and sentencing date was then scheduled, giving him an opportunity to take responsibility and follow through with the conditions of the agreement. It was a clear example of the court offering a path toward resolution, but only if the defendant was willing to do the work. The courtroom then moved on to another defendant, Lee Rogers, and this case took a surprisingly positive turn. At first, there was a little confusion because Rogers was appearing remotely and was having trouble using the mute and unmute functions. Instead of becoming frustrated, the judge turned the moment into what she jokingly called a little Zoom 101 lesson. After finally getting the technology sorted out, the court addressed the actual status of Rogers' case.